Hello, my name is Kenneth Fernandez. I'm a professor of political science at the College of Southern Nevada. And in celebration of Constitution Day, I decided I would record a little informative video regarding a case that I uncovered when I was doing some research on Nevada courts and state courts in general. The court case is Hiibel versus 6th Judicial District of Nevada. And although we're celebrating Constitution Day in 2021, this seems a bit old, it is still relevant. And in fact, just a few days ago, or let's see, at least a few days ago of when I'm recording this, and not necessarily when you're listening to this, this court case was cited in a U.S. Court of Appeals decision regarding a similar case of someone being arrested for not providing their identification. So I think it's a relevant case still today. And I find it interesting, being a Nevada resident and a political science professor that teaches both the U.S. and Nevada Constitution material. I thought this was an interesting case, not only just to Nevada residents, but to anyone who lives in a state, a growing number of states that have a stop and identify law, right? It's also interesting because the Nevada State Supreme Court and the U.S. Supreme Court were very closely divided on this case. So again, a controversial issue where, yes, a majority decided a particular opinion, but a slim majority. So I think this is an interesting case, and I thought I would spend a little time describing it. Now, this stop and identify is different than the sort of stop and frisk, right? What we might call as a Terry stop, which was discussed in a case, Terry versus Ohio, in 1968. Stop and identify, you have a growing number of states that are adopting this law where a police officer has the right to stop and detain an individual and ask them who they are, and any person so detained should identify themselves. If they do not, right, they can be arrested, right? So here we have the Nevada statute here, and one aspect of it, right, says any person so detained shall identify himself or herself, but may not be compelled to answer any other inquiry of any peace officer. One justice had noted that clearly the state legislature knew about the Fifth Amendment and, right, the protection of self-incrimination. So the law says identify yourself, that's required, but cannot be compelled to answer any further questions, right? So clearly I think the legislators in Nevada were aware of the Fifth Amendment in the Bill of Rights, and that we have a right to avoid self-incrimination, but that they wanted a law where to assist police officers in an investigation, providing at a bare minimum who you are, right? Identifying yourself. Seems maybe uncontroversial, but as we dig into precedent and sort of interpretations of privacy, maybe it's a little bit more controversial than it may first appear. So here's some of the facts of the case. Not all the facts, but some relevant facts, right? Larry Hiibel, a rancher in northern Nevada, was parked legally on the side of the road. He was with his adult daughter. The daughter was driving, so he wasn't driving, and they were having a verbal argument. Someone must have reported this or somehow, and a county sheriff deputy was investigating a possible report of an assault, right? The deputy ordered Hiibel to provide identification, and Hiibel refused. He was arrested, right? There was a trial in the Union Township Justice Court in Winnemucca, Nevada in 2000, and Hiibel was convicted under Nevada statute and was fined $250 and a $70 court fee. not a huge amount, right? Perhaps the average person would just let this go, pay the fee, but Hiibel didn't let it go. And that's generally the story behind many of the rights that you and I have. It was someone who didn't let it go and pushed it all the way to the U.S. Supreme Court to have them say, is this legal? Is this constitutional? Is this a violation of my rights? So a brief note that, like many states, right, Nevada's court system has some similarities to the federal system and other state systems. They have a lower level courts that are referred to in the literature as courts of limited jurisdiction, and these are referred to as justice courts and municipal courts, very similar to other states. You have 40 justice courts in Nevada, right? And they deal with evictions and misdemeanors and traffic violations and small claims and civil cases. Since this was a misdemeanor, we see that this case started out in the Union Township Justice Court, right? Which is in the 6th Judicial District up in the northern part of Nevada, right? So he is convicted, right, for refusing to provide identification. It's a violation of state law. And he appeals, right? And when you appeal a justice court, it goes to the district court in Nevada within that, typically within that, that district. So the appeal goes to the 6th Judicial District in Nevada. Hiibel argues that this stop and identify law is a violation of his 4th and 5th Amendment rights. 4th Amendment right of free from unreasonable searches and seizures, and 5th Amendment, which protects against self-incrimination. Right, so we recall that the 4th Amendment within the Bill of Rights protects against unreasonable searches and seizures, right? And that really this should not be violated except upon probable cause. Now, in Terry versus Ohio, when you're out and about in public, right, the belief is that the police can have a reasonable suspicion, which is a lower threshold than probable cause. So we have this 4th Amendment, but depending on whether you're in your home or out on the streets or in your car, the Supreme Court has ruled a sort of a different interpretation, right, of this application of the 4th Amendment. And the 5th Amendment, as we noted, one of the clauses within the many protections that were given under the 5th Amendment, one of the short clauses says, right, our rights should not be infringed regarding being compelled in any criminal case to be a witness against himself, right, or herself, of course. So we have this 6th District Court ruling to uphold the conviction of the lower justice court in the Union Township. And Hiibel appeals again to the Nevada Supreme Court, requesting a writ of certiorari, which is really just a request to review the lower court case, the district court case. So it goes to the Nevada Supreme Court, right? Typically, right, a ruling in a lower justice court cannot be appealed to the Nevada Supreme Court because the district court is the final appellate jurisdiction. Only in special circumstances can you appeal a district court ruling to the Nevada Supreme Court if the district court judge, right, has overstepped its jurisdiction, or there is some other violation of your rights, right, or it relates to perhaps a violation of a right protected by the U.S. Constitution and the Bill of Rights. So Hiibel argued that the district court judge in the 6th District went beyond his authority by ruling that the stop and identify law was constitutional. A district court judge in Nevada can't do that. That would be something that the Nevada Supreme Court. So he argued that this district court judge went beyond their jurisdiction, and therefore the Supreme Court could review the case, right? Which is a good argument if true, right? But we see that the Nevada Supreme Court didn't buy that argument, right? They argued that the judge in the 6th District Court did not actually rule on the constitutionality. It did not overstep their jurisdiction. But it was a close vote, and 4-3, right, vote. The Nevada Supreme Court basically goes beyond just saying, not only did the district court not rule on this, but we're going to rule on it, and we're going to say that this stop and identify law in Nevada does not violate the Fourth Amendment because it strikes a balance between constitutional protections of privacy and the need to protect police officers and the public, which of course is just an ongoing balance that we're always trying to negotiate, whether it's Miranda rights, right, telling a potential suspect that this person, you have rights, you have the right to remain silent, right? Some people argue that we shouldn't be trying to help potential criminals, right? And so balancing people's rights and the need for public order has been a controversial issue for decades and decades and decades, centuries really, right? So here Nevada Supreme Court refused to revisit this case. And so Hiibel also asks not just for a writ of certiorari, but for a rehearing, right? A petitioner can ask for a rehearing if they feel that the court has somehow overlooked or misinterpreted certain facts or misapplied or failed to consider a certain statute or rule. And it's a typical, if you get denied your writ, often you can request a rehearing. That was denied. And so, no surprise, Hiibel's not going to let this go. Thank goodness that we have people that are this tenacious, right? And so we have 3 years after the fact of his arrest, the state Supreme Court rejects not only his writ of certiorari, but his petition for a rehearing, right? Now, some members of the Nevada State Supreme Court, right, disagreed with the majority, right? Justice Auguste, along with 2 other justices, dissented and argued that there's a well-established precedent that, yes, officers can stop, detain, and even question a person, but the detainee need not answer any questions, right, including identifying themselves, right? And they cite several cases, including one here in Nevada, Carey versus Nevada Gaming Control Board, where you have judges that sort of interpret the Constitution in this way, that you don't have to answer these questions, right? So even though it was a close vote, Hiibel loses in the Nevada State Supreme Court and appeals to the U.S. Supreme Court. And as we know, the U.S. Supreme Court does not hear many appeals, but clearly this is an important issue. It's a controversial issue, and the U.S. Supreme Court feels necessary to rule on this issue. Hiibel makes the same argument. The Nevada law, stop and identify, is a violation of both his Fourth and Fifth Amendment rights, right? The Supreme Court disagrees with Hiibel and confirms the Nevada State Supreme Court decision, right, in a close, divided 5-4 court, right? Kennedy, typically a swing voter, and in this case swings towards the conservative side of the court, making the difference. He writes the majority opinion, right? And he argues that identifying oneself is not self-incrimination. You're just telling the police officer, a law enforcement agent, not a stranger, well, I mean, maybe a stranger to you, but a duly appointed law enforcement agent, your name, who you are, right? Now, of course, if all the police are looking for Kenneth Fernandez for some type of crime, asking my name is self-incrimination, right? Now that's a hypothetical, of course, right? So the court ruled that Hiibel's arrest for refusing to identify himself was not a violation of the Fourth or Fifth Amendment rights. You had 4 Supreme Court justices that dissented. They disagreed. In a separate dissent, Stevens said that self-incrimination extends beyond the courtroom to situations like Hiibel found himself, face-to-face with the law enforcement. He had not committed a crime, and he did not want to provide his identification. He didn't want to answer any questions, right? And Stevens disagreed with the majority that believed that identifying yourself was not self-incrimination. He believed that it could be considered self-incrimination. In a separate dissenting opinion, Breyers, joined by Souter and Ginsburg, they cite Terry versus Ohio and say, yes, police with a reasonable suspicion can stop you, detain you, and ask you questions, but there are specific limits, right? And one of those limits invalidates laws that compel people to respond to police questioning. They cite Terry versus Ohio, where the Terry stop emerges and is still sort of precedent today. They cite that controversial case to support their argument, and they cite a concurring response within that decision in 1998 written by Justice Wright, who I wanted to note that my son, who recently graduated UNLV with honors, wrote a paper on Justice White, and I did not know that he was a professional football player before having a distinguished legal career. Just a side note. But Justice White writes, of course the person stopped, right, is not obliged to answer. Answers may not be compelled, and refusal to answer furnishes no basis for an arrest, although it may alert the officer to the need for continued observation. So by not giving your name, the police may have very reasonable suspicion to detain you even further, temporarily, but even further, but not to arrest you, right? Or charge you with the crime and convict you for not providing that identification, right? So here we have this established concept, but we seem to be revisiting it and modifying it. So here Hiibel, right, he wrote an op-ed in the Christian Science Monitor in June 28th of 2004, titled, "I Fought the Law and the Law Won." And you might ask yourself, why would a person refuse to identify themselves to law enforcement, right? This person is probably pro-law enforcement, right? In an average, given day, right? When we're face-to-face with law enforcement, we're never really thrilled about it, right? When we get a speeding ticket or parking ticket, right? Or what have you. Why would a person spend years fighting in court over a fine that added up to $320, right? And he was represented in the beginning with the public defender, right? And here's what he writes, and you could go find this article yourself, right? Here's why this was so important to me. I don't believe that the authorities in the United States of America are supposed to walk up to you and ask for your papers. I thought that wasn't lawful. Apparently I was wrong, but I thought that was part of what we were guaranteed under the Constitution. And we only know these things when we question these laws, right? We question authority. We may lose, but this articulation is an important part of the establishment and evolution of our rights, right? If people didn't question a law banning access to contraception, then we would, perhaps never have the right to privacy that was established in Griswold versus Connecticut, right? People questioning authority, questioning old laws, questioning new laws, right, is how we articulate our rights in an ever-changing, complex society, right? And so I find this interesting because one, maybe my guy lost, but we learned something through this articulation. And I'm so thankful that there are people like Hiibel that will go through this process so that I can learn more about my Fourth and Fifth Amendment rights and learn more about Nevada law. And you can even watch, because of dashboard cameras, you can watch the video of the arrest on YouTube in this modern, amazing technology world that we live in that brings up new violations of our presumed privacy, right? That bring up new questions. And I think these cases are extremely important. They're important for law enforcement to know, what's legal. And Arizona actually has a law that is similar to Nevada, but it requires police officers to explain the law. That, you have to do this. You could be arrested. This is the law. Because I think a lot of people do believe that they have a right to remain silent, right? So Hiibel may have lost, but he barely lost, but lost nonetheless. But clearly, this divided court shows that this stop and identify is controversial, and it could be revisited in the future, right? This is 17 years old. It could be revisited by a different court sometime in the future that may see this differently, right? Precedent has power, but we do sometimes see the Supreme Court, U.S. Supreme Court, reverse itself regarding past precedent. And of course, balancing the government's interest with personal rights of privacy is always controversial, and it is an important theme when you study sort of legal application of criminal law. I think part of me thinks that providing your name or even your identification card to police officers is the least we can do in some cases in a society that we do value, public law and public safety, and fighting crime, right? But we do have to see that, right? We have something in the Constitution that talks about probable cause, and then we say, well, when you're out walking on the streets or driving around, well, police don't really need probable cause. They need reasonable suspicion. To invade your house, maybe they need probable cause. So we're changing our interpretation of these things in one way to make police officers' jobs easier. And that can be a good thing for public safety, but we don't necessarily, the purpose of our Constitution isn't to make the life of police officers easy, or detectives, right? Or to capture criminals easier, right? The point of our U.S. Constitution and Bill of Rights are to protect our rights, right? And I think Justice White making the argument that refusal to answer questions does not furnish a basis for arrest, that was an important caveat to Terry in Ohio that seemed to be disappearing. And the Nevada Supreme Court and the U.S. Supreme Court seem to be saying, yeah, but individuals should have to answer at least one question. Who are you, right? Show me some identification. And I'm sure many of you listening to this would say, yeah, that seems obvious. And I think there's a half of me that does agree with that, right? There's another half of me that says, when the police officer arrived and they observed that no one's bleeding, the daughter is not asking for assistance, no crime is happening, there is no need necessarily for invading someone's privacy or mandating that they answer questions, right? When you can observe the situation, right? He could go and ask the daughter, are you okay, whatever. Of course, clearly in a domestic violence situation, which this does not seem to be an issue, maybe the daughter or a wife or whoever, a girlfriend, would feel intimidated, right, not to answer. And so clearly the deputy needs to investigate. But does it mean that we can arrest someone for not answering questions, right? Even the simple question, who are you, right? I mean, really, prior to Hiibel and the growth of these stop and identify laws, refusing to identify yourself would just really give an officer a reasonable suspicion to detain you even further. And most of us would comply because we don't want to be detained any further. We'd like to go on to our job or back to home, right? But we wouldn't be convicted if we were refusing to participate, right? But we could be detained even further. That would be the penalty. But we wouldn't be arrested and convicted and have something on our permanent record, which could affect us, right? Getting a job or what have you. Now, under these stop and identify laws and this ruling in Hiibel, right? Police not only can detain you temporarily for refusing to identify yourself, but they can now arrest you, and courts will now convict you for simply saying and doing nothing, not complying, right? And this does go against popular belief among many citizens that we have the right to remain silent, right? But perhaps under Hiibel, this only applies after we are arrested, right? And we do seem to be a nation that has the highest incarceration rate of any sort of industrialized democracy, right? You have to look to some very specific nations to find countries that lock up their citizens at a higher rate than we do, right? So we do like to arrest people, right? During the drug war, right? And of course, in the fight on terrorism, the fight on crime, police asking who you are seems to be a minor inconvenience in the overall public safety. But just as someone may feel that mandating wearing a mask in a grocery store is a minor inconvenience, another person may say that is a violation of my rights. And these court cases are where we articulate these things in, I would argue, a relatively calm, academic, intellectual, right, legal fashion. And that's why I think I find, even though I disagree with this decision in part, I find that I am more aware of my state law, my rights, right? The problems that face police, the problems that face people that are accused of being a crime, even though they're innocent, right? And so I find this to be an interesting case, and I hope you found that it's an interesting case, and I hope that you do more research regarding our constitutional rights.